question document exams that deal with documents having issues of authenticity. Maybe perhaps the document is there's a kind of dispute. There's a dispute on the origin or authenticity of the document. Then what you use to confirm or to refute that document is original is for question document examination. Another name for question document examination is forensic document examination. Forensic document examination. Please, you don't need to jot anything down because the class is being recorded. At the same time, we are going to have the handout after this. Just listen so that you can have questions. You may just, if you have questions, you may just jot it down so that at the end of the class, you may ask a question. But let us listen. So question document examination is a branch of forensic, and question document examination normally use, because it's science, we use scientific methods and techniques. Scientific method and techniques. And question document examination is not the same thing as graphology. We talk about graphology later. It's not the same thing as graphology. So graphology infers people's character or personality of the writer, whereas in question document examination, we use analysis or examination that we do to infer the source of the document, to say whether the document is genuine or not, whether it is authentic or not. So it's totally different from graphology. So, but let's move forward. What is a question document? A question document is any document whose authenticity, origin, authorship, or integrity is disputed, and therefore requires scientific examination. Just as I told you that question document examination uses scientific methods and principles or techniques. So when you have a document that is being disputed, then what we use to confirm the allegation is scientific examination. Scientific examination. It is scientific because what we use for this examination, they are measurable, and they are those things, those factors that anybody can use and still get the same result, which means it is reproducible anywhere by anybody. We follow the same method, that we follow the same thing that we do, we get the same result anywhere. So if like 1,000 or more than that, or question document examiner will work on the same question document, they are going to get the same result. Please, can you hear me?
Yes, sir. We can hear you loud and clear, sir.
Yes, sir. Okay. We can hear you, sir.
Okay, please, Mr. Inyang, Officer Inyang, please. Probably your device is malfunctioning. Maybe you try to log in again. So a question document is any material. A question document is any material containing marks, symbols, or signs, visible or partially visible, that convey meaning. Sorry. So, a question document is any material containing marks or signs, visible or partially visible, that convey meaning or intended to convey meaning. For example, it is not only paper that we call document under question document examination. It's not only the paper that you call document. A work can be a document. Even the body of a cadaver can be a document. Any material, including digital device that will contain any marks or symbol or signs, visible or partially visible, that is intended to convey a message. For example, if a wall, or let's say a wheel of a deceased contains a mark like a fingerprint, contains a fingerprint. That pattern fingerprint, I'm talking about pattern fingerprint now, fingerprint that is visible. A fingerprint that is visible is called pattern fingerprint, unlike the one that is not visible, that an expert in fingerprint examination will have to work on it. But I'm sorry, but fingerprint, because can convey a message to somebody. For example, if you see a fingerprint, a fingerprint on a document, if you look at it very well, and that fingerprint, that mark is telling you that somebody touched it, or somebody impresses, and use that one to link who impressed the fingerprint on it. So, or a mark like signature or handwritten, or maybe just a mark of event, that intended to convey meaning, is known as material is called a question document, or a document that might call a document, but we call it question document. That is when it is any of those things like massive or sign on it is putted. When it's being deployed, then and so that's a document. Please give me just a second. Let me attend to this person that is disturbing me, please. Thank you. Yes, please, are you with me?
Yes, sir, we are together, sir.
Okay. Now, but in modern forensic science, it has been expanded to include electronic and digitally generated documents. Initially, it was just those paper manual, you can call them manual devices, like paper, like canvas, like clothing, or even body of a cadaver. But now it has been expanded to include electronic and digital generated documents, because these days many of our documents are now going. Many organizations are having their documents on the digitally. Even many are having it on the cyber. So those documents are also, they are still under what we can work upon and confirm whether they are genuine or not, whether they are authentic or not, or their sources. Even this document, this computer generated documents, many of them are even more prone. They are more prone to fraud than others. But it doesn't matter whether they are prone to fraud or not. A trained question document examiner will still work on them and confirm the source or whether they are genuine or not. So there are examples of this kind of document that question document examiner work upon. They are signatures. Examples are signatures, contracts and agreements, ballot papers, checks and financial instruments, anonymous letters, official records and certificates. Briefly, let me just say one or two things about the history. You know, this topic is on introduction to question document examination. Introduction to question document examination. And what we are doing today is that we are laying a foundation. By next class, we go deeper into the course. Early development of question document examination. The scientific study of question document examination began in the early 20th century. Albert S. Osborne is widely regarded as the father of modern question document examination. His work, known as a question documents in 1910, laid the foundation for systematic handwritten comparison. In fact, the major work that started question document examination is that of handwritten comparison. Later, some other things now joining, some other fields, sub-fields join this. So from 1920s to 1950s, court began accepting handwritten experts as witnesses. Then, between 1960 to 1980, there's an introduction of laboratory techniques, such as ink analysis and paper examination. So today, we can examine a paper and say this paper is not as old as the document, as the date that is alleged for the creation of the document. For example, some people may say a document, maybe a document that is meant for a contract or a land paper. Maybe they want to say it has been existing. Maybe our family and your family had agreements some 50 years back, and they are tendering the document that this is the document that our father, our fathers or our parents, this is the document they use them to agree on the sales of the land. But after you might have worked on it as a question document examiner, you discover that it may be the paper that will help you to discover that the paper or the ink on it that will help you to discover that that document is not as old as they claim. And that one will help you to know that this is nothing but a fraudulent document. So we can work on the paper, you can work on the ink using laboratory techniques, that is scientific techniques, to know that a document is forged or not. Even when the document is typewritten, you can still work on the paper and the ink and know that the document is not as old as it's claimed to be. Then between 1990s to the present, then we have integration of digital forensics, including printer identification and electronic document analysis. Today we can analyze electronic document and say, no, this document is not from this source, or this document is not as old as it claimed to be, because electronic document, just as I said earlier on, is very prone to manipulation. But there is always fingerprint that you can use to know that this thing has been tampered with. For example, there's something we call metadata on every document that you create with any device. So that metadata is not always visible to an ordinary person. But to a question document examiner, you can look at the metadata and say, this document was created by Mrs. Akisanya, and but on another device, another person, Mrs. or Mr. Ahmed, had tamper with it, that is modify it. That means it has passed through the two devices. So I can, as a question document examiner, I can now look at the document and say somebody had modified it. This is not originally from Mrs. Akisanya again. It had been tampered with, it had been modified. And even the date of modification, the device that was used to modify it, and the time and some other information, I can bring them out as a question document examiner to tender to support the argument that the document had been manipulated. So that one is possible these days. So let's go further into the roles in civil and criminal litigation, the roles of question document examination in civil and criminal litigation. Let's go to criminal litigation first. In criminal litigation, question document examiners assist court in identifying forged signatures. There are places, especially in Nigeria, we have a place called Oluwole in Lagos, where there's no document that cannot be forged. Even by the time the original owner of that signature will see it, he will be arguing within himself that, well, this is my signature, but I can't remember when I signed it, because he's already confused and convinced that he was the one who signed it with what he saw, but he couldn't remember when he signed it. But a question document examiner will examine it and bring out some characteristics, some things in it, some evidence that this thing was not signed by the original owner of the signature, that it was a copied work, which an ordinary eyes will not be able to see. So all these things are what we are going to work on in the course of this study. So another thing that question document examiner do is that they help in detecting altered documents. Some documents might have been altered perfectly that even the original creator will not even know. For example, a word might have been removed, or a page might have been substituted, or a line might have been inserted, which will change the meaning of the whole document. But it can be done perfectly this day, where you have a printer or some devices that they can use. So but a project document can still work on this and still bring out the those part of it that were removed or inserted, or some other things that were not part of it from the beginning. Another is examining ransom notes and anonymous threats. Examining ransom notes and anonymous threat. A ransom note is a note that somebody that you don't know wrote in order to get something from another person. Let me give an example. When somebody is maybe kidnapped, a man is kidnapped, and the kidnapper now writes a note where his family member can see it and say, if you don't send so to me, I'm going to, this person is going to die, or I'm going to do so, or I will not release him. That note is a ransom note. Even though the writer might have disguised his handwriting, yet we can still work on it and discover who wrote it, the source, if you have suspects. Then there are times in criminal investigation that we may see a kind of note that we call suicide note on the crime scene. The suicide note may say that, well, I'm not the one killed. I mean, I'm the one killing myself. Nobody should cry for me because of what I'm passing through. Therefore, nobody should cry for me. I just want to go and rest. Now, somebody among the family members may just come up and say, no, I trust my dad or I trust my friend. He can't kill himself, he can't commit suicide. Something is fishy. Now, a mother's case will now, because of that allegation, will now turn to a suicide case will now turn to a murder case, because after the question document examiner have worked on it, that person, the question document examiner will reveal that the purported suicide note is nothing but is somebody who wrote it, a mother who wrote it, and trying to make the murder case to look like a suicide case. So from that now, a suicide case, an initial suicide now turned to a murder case. So that will help the investigator. So another thing is when you have anonymous threats, maybe a letter from somebody that you don't know, or it may be digital, like you have it on social media, or read paper letter. It can be examined and we can still get the source. Or we don't use it only to confirm the source, we also use it to refute, to exonerate a suspect. So, and their findings may support prosecution or defense by providing evidence. So then let's go to civil litigation. In civil litigation, they play key roles in disputes over contracts and agreements, over will and testament authenticity. Will and testament authenticity. In fact, this is very common among our people. You see, maybe their dad before he died had promised them one thing, and after that, after the demise of the man, they discovered that what the man said is not in the will, or they believe they have right to certain part of the man's property, and now what their expectation is not met inside the will, they may challenge it, and when they challenge it, they are at times, in most cases, there are two things that we normally use for the authenticity of such a document. If the man is literate, then he might have signed. Then we use the signature. We work on the signature to authenticate the will, the document. But there are cases where the man, even though he was rich while he was alive, but he couldn't read all right, but he used his thumbprint to authenticate the document. So we can work also on that rule, on that patent fingerprint, to know whether the document is authentic or not. And the way we do this one, these are some of the things that we are going to do in this course. So will and testament authenticity. Then we have banking and financial fraud cases. So at times it may be a case of financial fraud. Maybe somebody inside the bank and another hacker outside now get access into the banking data and steal some data which they used to steal. No way, steal data, you are also stealing money. But in many cases, this way is something that is very difficult to do unless there is an insider, because organizations, especially banks, their system is always secured. But when they have somebody from inside, it can be easy for the outsider to break through. Then they play key roles also in employment related document disputes. Then let's talk about the evidential role. The evidential role. Expert provide expert reports. In fact, the purpose of your investigation or of your examination is to give a report, an unbiased report, so as to help the court to take a decision on that aspect, because you are an expert. Because you are an expert, you can interpret what your findings to the court in a way that the court will be helped in order to take the right decision. So expert report is one of those roles that you take, the evidential role that we play. Expert report. So you write a report, and the way you write a report is you will write it in a manner that the court will be able to understand it. Even a layman will read it and understand. But when it is not properly written, it may be difficult for the court to accept it, to admit it as an evidence. Or when it is not properly done, because there are rules that you have to follow, all these things will be treated later that you have to follow, and that one may make, if you don't follow the right will of written report, an opposing counsel may use that one to destroy your testimony. Your testimony may crash if proper ways of written report is not followed. Then another rule is that of testimony, court testimony. One thing is to write a report that will be admissible in the court. Another thing is that you yourself physically may be in the court to testify of your findings, of your examination, or of your investigation. So there are two different things. So if you get to the court as the court is expecting you to, the court may be expecting you to come and give testimony, to come and say verbally what you have done, your findings, to come and explain your findings. And thirdly, it may be that the court may want you to come and demonstrate what that thing, that is a demonstrative exhibit. For example, a question document examination, you may get to court and there's a way you can demonstrate how you conducted your findings, how you come about your findings, how you compare the signature of Mr. A to Mr. B. Those things that you saw there, you bring it out, and by the time you explain it, the court can understand in a very layman language. Everybody will be following you, and the court will understand what you have done. Very well. So you can the opinions, that is the opinions of question document examiners, must comply with rules of evidence, such as we have in Nigeria, like Nigerian Evidence Act 2011, section 68 to 71 on expert evidence. Then let's move further to elements, to relationship between lawyers and forensic investigators. The relationship between lawyers and forensic examiners. The relationship between lawyers and legal practitioners, and between legal practitioners and forensic document examiners, is collaborative, but must remain professionally independent. What do I mean by that? What do I mean by that? There are some things that you cannot do as a question document examiner, and there are some things that the court is expecting from you. Let's talk about the key element of the relationship, of this relationship. The first one is instruction. Instruction. Lawyers brief examiners on the issue in dispute. the scope of the work of the examination or of the forensic investigation must be stated. So that you work within what is supposed to be worked upon. In a document, there may be a lot of things that you can work on as a question document examiner, but instruction will guide you on what to do, whether it is only the signature that the lawyer wants you to work upon, or the handwritten, or the fingerprint, or the entire document. So the instruction must be clear. Then another key element is independence. Examiners must remain objective and unbiased, even though your client is the one who pay you, but yet you have your first duty is to the court. Your first duty is to give an unbiased report to the court. So at times, it will be okay for you as a question document examiner, after you might have see your findings, after you might have concluded on your investigation or examination, to tell your clients that this is what you have seen, and this thing is against you, instead of supporting him for what you know will go against him by the time you get to the court, especially when another question document examiner will look at that report. Maybe from the other side will look at the report. So tell the truth if it's going to go against that. So your report must be objective, must remain objective, even though you are being paid by the client. You'll be objective and unbiased, because science is the same all over the world. So if another person is going to work on that thing, he will get a different result. If you follow normal protocol, you're going to get a different result that will expose the work that you have done. So the best thing and the rule of the thumb is to be objective and be unbiased in your report when you are giving your report. So another key element is communication. Clear explanation of findings in understandable terms. In fact, not only to the court, but your lawyer also. Because you are not the owner of the case, you are just a scientist that is called to come and examine an evidence. So to write your report. So in that case, you must make your report so well understandable. No jargon. To the extent that the lawyer, while he's standing in the court to make his case, he will be able to speak a language that was spoken. That is, whatever your finding is, you'll be able to present to the court in a manner, you will be able to argue in a manner that will not be contrary to what you have, your findings. That will be contrary to your findings. And also the court, your report must be written in a way, in a manner that your findings will be understandable. Then, lastly, on key element is disclosure. Full disclosure of your methods, all the methods. In question document examination, there are a lot of methods that we use, which we are going to also deal with as we are going along on this journey. There are a lot of methods, but all this methodology, majority of them is about comparing known to the unknown. Comparing known to the unknown. That is comparative analysis. You compare what is known to unknown and you use your findings to say this one is not part of this, or this one is not from this source. Let me give an example. Everyone has a fingerprint that is unique to him. So if I'm using my fingerprint as a creator of a document, maybe a will, if I use my fingerprint, because my fingerprint is unique to me, to my own. If anybody is challenging the document, maybe after my demise, if anybody is challenging that document, all they need to do is go and get all the documents that I've completed in the past while I was still alive. Different type of document, maybe the one that I wrote to the bank, the one that I wrote to some people, and all these documents will be gathered, and they will use that one because they are known document. They will be used to authenticate that one that is under dispute, that is being disputed. So what we do is that we compare known to the unknown. A majority of what we do in question document examination. So okay, let me leave that one now till later, maybe next week. Then if there's any limitation, there are times you have limitation on the work that you are doing. For example, a question document examination, if the signature that you have to compare with others, if that signature, the one you are able to get, the original signature or the no signature of the deceased, is, if you don't have enough, you have some, but you don't have enough, because there's a standard for the numbers of what you should have. If you don't have enough, you should write it there that you don't have enough, and that one can affect the outcome of your result. So that limitation must be declared. Then if there are uncertainties like, for example, maybe in the case of a signature, for example, now, some of the signature that you saw, that they brought to you, some of them are being at home, and where they store the document from which you got them, the document has been tampered with because of high humidity. Some of them are no more in their rightful structure. So that one may bring a kind of uncertainty that will not allow your result to be okay. So that one must be there. We must not hide it. Then what are the ethical considerations? We are still under the relationship between lawyers and forensic examiners. Relationship between lawyers and forensic examiners. Ethical consideration. You must, as a question document examiner, you must avoid advocacy bias. Advocacy bias. That is when a scientist is now doing the work of a lawyer. In fact, if you are a lawyer and you are trained as a question document examiner, your report must talk like a scientist. Then it is when you get to court as a lawyer now that you talk like a lawyer who understand science, who also trained as a question document examiner. But the report must show that what you have done is scientific. So if you now stand wearing your wig as a lawyer, you may now combine the two together. The knowledge of the two fit together. But when you are writing your report, it must show that you use science and not impossible. So you must avoid advocacy bias. Let me give an example of advocacy bias. After an examination, you want to write your conclusion, and you said the signature I observe is not inconsistent with the known signature of the deceased or of late Chief Dada Udoh. No doubt, there's no doubt that that signature is forged. The word "there's no doubt," that is advocacy. That is your advocacy. It is not your job to say no doubt. In fact, there's no science. There's no science. There's no scientific examination or scientific investigation or experiment that will give you 100% certainty. There's always a percentage of uncertainty, like It may be as small as 0.so. Even when there's a DNA, where there's a DNA of two of a child and his father, where there's the report will always say 99 point so percent, 99 or 90.so%, which means the resemblance, I mean the resemblance is consistent with the father, of that of child is consistent with the father. But you can't say 100% because there's always a percentage of uncertainty in any result. So, but when you say there's no doubt, that means there's you are sure 100%. That is advocacy. That's advocacy bias. Then you must maintain confidentiality. I think that one is understandable. You have to adhere to professional standards. Some of these standards will be mentioning it later in the next class. Professional standard must be. Let me just mention one of them that can knock off any report, whether it is that of a question document, examination report, or any other scientific report in the court. It is when you are the forensic science or forensic investigators or forensic examiners are to work in the area of competence alone. In the area of their competence alone. So this is one of the professional standards. When you are not working in the area of your competence, then that report cannot be admissible. First, let me give an example of a case. A graphology work on a question document. And nearly destroy evidence of a lawyer. Let me put it that way. But when we are called to work on that same work, what was used to crash his work is the fact that after he finished his work, he wrote inside the report that he was trained as a graphologist. His designation was a lead graphologist. He called himself lead graphologist, and inside his report, he also stated is that he and his team of graphologists. So we have to say that no, this man is not working within his area of expertise, because he's an expert as a graphologist, but not as a question document examiner. And question document examination it can only be done by a trained question document examiner and not a graphologist. So even though it's possible for you to receive training as a question document examiner and also as a graphologist, but those two fields are not the same. A question document examination is a branch of forensic, whereas graphology is not a branch of forensic. So if you work, though both of them they work on handwritten, but the handwritten that we work on as a question document examiner is different from the one they do in graphology. Now, assuming a man is trained on the two fields, if you are going to write your report must show that you work as a question document examiner and not as a graphologist. There are two different things, two different fields. One is a science, the other one is not a science. Even though nowadays they want to brand themselves as branch of forensic, but community of scientists throughout the world never accept them and never accept graphology as a science. So let's do that. So we must adhere to professional standard. Not adhering to professional standard may affect all the work that we have done. And I just mentioned one of the operational standards, but later I will discuss about some of them. I mean, the rest. So what is the importance of collaboration? Number one, proper interpretation of forensic findings. Proper interpretation of forensic findings. If you, by the time you collaborate with a question document examiner, maybe at times you may have one or two or three question document examiner that you collaborate with and lawyers on a job. It will make the work, because everybody, one of them will see things from different angles. It will make the job to be okay. It will make it to be better. Then another importance is stronger legal arguments. Collaboration with question document examiner. We are talking about relationship between question document examiners and legal practitioners. Stronger legal arguments, because you understand everything about question document examiner now. Then it will help you to put up a stronger legal argument. Then another important is enhanced administration of justice. Enhanced administration of justice. Quickly, let's go to overview of document fraud trends in Nigeria. Overview of document fraud in Nigeria. Document fraud is prevalent in Nigeria across multiple sectors. And the common type of document fraud we have is number one, forged academic certificates. Today we have a lot of that from different institutions. See somebody who need an employment, we forge certificate of an institution, but there are always a way of examining this kind of document and certify that is genuine or not. So forged academic certificate is number one. Number two, altered financial documents like checks or invoices. Check at times, letters or figures on checks, like for example, 30,000 may turn to 130,000. And one thing with forensic investigation is this: there is always something to use to reveal the different pen. If two pens were used to write on a check, you can easily know there's something you can use. I will bring that in the next class. I will bring it and demonstrate to you. If you have on a check, for example, a director wrote 13,000 and somebody else now added 1 in front of 13 and turned the whole thing to 130. Now, by the time there's a divide that you shed on the document, on the check, and it will reveal that two pen were used to write the figures on it. For example, the high, even though both of them may be blue or black, the one in front of 13, I mean in front of 30,000 turning to 130, that one will show light differently, will reflect light differently, and the other 30,000 will have the same reflection. So these are some of the things that we do in question document examination. So another common type of document fraud is identity document fraud, where a original document may be stolen and one or two things will be added to it for another person to be used, or the whole thing may be a fabrication, like a national ID and some other passports. Then we have land and property document forgery. This is very common, very, very common in court. Land and property document forgery. And there are ways of authenticating them by a trained question document examiner. All these things will be done in the course of this study. Then, lastly, we have electoral document manipulation, that is ballot papers or the resource sheet. Last week, was it last week? Yes, last week we discussed on forensic investigation of ballot papers. So if there's a way of investigating every document and you discover what is unknown, what is not consistent on that document, what is not consistent on that document. The emerging trends of these fraudulent activities in Nigeria are this. Today we have high quality digital printers that you can even use to print some security documents, highly security documents like money. There are printers that can print them, but there is always a way of detecting them also. There is always a way of detecting them. So there's a manipulation of electronic documents. Today people can manipulate even PDF. Some people believe that PDF is secure. When you create document in Word, you convert it to PDF to make it more secure. But let me tell you, it can be manipulated and you not even know that has been manipulated. So, but there's always a way of finding out. All this will be treated. Will be treated in the course of this study. Then, let me, because of our time, let's go to practical component of question document examination. The practical components of question document examination. The first one is handwritten analysis. In this course, we'll be examining different question document. I mean, different handwritten. We bring out handwritten and we use it for practice. Then another thing is signature verification. In fact, we do a lot of that one. Signature verification, so that we can know how to, in fact, because signature is one of those things we use to verify or use to authenticate document. So it's one of those things that we are going to concentrate on, how to verify signature in order to detect forgery. Then another practical component is ink and paper analysis. We discuss that, not just discuss, we will put that one also into practical. How to determine the age of a question document. How to determine the age of a question document. Then another component is alteration detection. How to detect if there's alteration. Maybe a part of a document has been removed or something has been added to it. Then another component is that of printing and typewriting examination. It is not only handwritten. It's not only document that were created and all this one also, there are ways of examining them. We are examine them and we can identify this printer that was used to print it and know the source. Then lastly, digital document examination. I made mention of metadata the other time. There's a way we can conduct examination on a digital documents. You know, many of institutions today, many of organizations, their document is now going to the internet, to cyber. So which means it is easy for a hacker or somebody who want to manipulate any document to hack into it or to get access to it and manipulate it. But at the same time, there's always a way of detecting all this. And what we use is analysis of the metadata, which we are going to do. is one of those things that I've got to put into practice. So, and lastly, another practical component is report written and court presentation. Report written and court presentation, which must be clear, structured reporting, use of demonstrative exhibits, expert testimony under cross-examination. In fact, that one, we will concentrate on that one very well. Then, because of time, is over and now. In conclusion, question document examination is a vital branch of forensic science that plays a critical role in both civil and criminal justice systems. As document fraud continues to evolve, especially in Nigeria, the importance of skilled forensic examiners, proper legal collaboration, and modern technological tools cannot be overstated. I'm going to stop here this morning. If there's any question, please, in the next 2-3 minutes, let's send it so that, or maybe later, but I wish you bring up your question now so that you can talk about it before we call it a day. Any question? If there's no question, let me know so that I can stop today. Okay. Mr. Wasiu, yes, please, your question.
Yes, sir. Good morning, sir. My question is, you mentioned that question document can be any document that contain information like symbol, letter, and so on and so forth. So my question now is that on tattoo, because there are some tattoo they usually write in a word or a symbol or a logo, can that also become a question document?
It can become a question document. Supposing the one who has tattoo on him, came to a house, for example, and raped a lady, and the CCTV now just carry was able to capture the tattoo, not even the face, the tattoo alone. It is possible for us after analysis of who and where exactly can we get this kind of tattoo, or who are there are some tattoo that are peculiar to a group of people. There are some tattoo that is only somebody, maybe a tattoo maker somewhere, that can do it. So that one can help us to trace and get the source of that information. That tattoo is an information that can use to link the carrier, that rapist, that assailant, can use to link it to the crime scene. So the body now becomes a question document. Who is the owner of this tattoo? Who is the owner of this body? Is now, that time is a question document. Thank you.
Yes, sir. Thank you, sir.
Yes, ma'am. Mrs. Akisanya. Your question, ma'am. Unmute yourself. You are muted.
Hello, sir. Good morning to you and the house. Please, at what point can we bring in a forensic expert on this question document? Is it while the police are undergoing their investigation? But I don't know where we can, the most appropriate time the expert can come in, so that it will be abreast of the investigation is being carried out, or that he is carrying out. Thank you.
Yes. Thank you, ma'am. The best time, if the best time is the time where the case is yet to get to a stage when the other party are saying, now this document is not correct. So that before if you are the one that is suing the other party, what they call it, if you are the one suing the other party, let a question document examiner work on that document first and tell you that your document is genuine or not, so that you won't get to court and be relying on what is evidence that you think is evidence that will crash at the end of everything. So the best thing is to call in a question document earlier, before the case will get to a heated zone. So the best thing, if what you are taking to court is already known to be a forged document, then the best is to drop it and resort to using another means. So, for example, there are cases where landed property was sold to somebody, and that document, probably the one they sold it to, the man has died, and their children now is the one that's suing the other party. They want to claim their land, the land that was properly sold to their father. But by the time they brought the document, we discovered that that document was not even genuine, because the document is talking about a landed property of over 50 years, and the paper that was used to create the document that you want to take to court was not even as old as 20 years. So I have to tell them, you can't tender this paper in court with this evidence. This document is not as old as 50 years. So the best thing is to call in the examiner before the case will reach a level that you cannot remove that evidence again. If you have already tendered it, it may be difficult for you to say no, this is not what you wanted to use. I think you understand me, ma.
Hello, sir.
Mr. Akinsola.
Yes, sir. Hello, sir. Thank you very much, sir. I want to ask two questions, but one has been answered by your last the last question. But I want to ask, in criminal matter, particularly when the state is tendering the confessional statement of the defendant.
Yes.
Now, what we see in practical experience, in practical experience, is that most of the defendants are illiterate, and the IPO or the police officer must have agreed to write the statement on their behalf and now ask them to append their signature. At the point of sending the document, the defendant will be telling the counsel that, well, I am not the author of this document or the statement. I was being beaten, I was being tortured, but they asked me to sign. But the defense counsel will be arguing in that line, but the state will be saying, well, since is it not your signature? Because it's only focused on the signature, but the character, the statement, the body is different for the signature. How can some of us who have the little experience in as regard this class, how can we wriggle out of this issue by objecting to the document or the authenticity of that document? In line with the question of my oga just asked, Mrs. Akintoya.
Okay. When we write, there's a vital part of us that assists us in writing, and that's our central nervous system. Our central nervous system. Somebody who writes under duress of fear, his signature will be different from somebody who's written under normal condition. So when you after analysis, there are something that will show up in the signature of that man that he wrote under duress, apart from the fact that there's going to be difference between his signature, because the signature is still part of handwritten, and the one that was written by the police officer. So there are two things there. One is the signature will be different. You can deduct the strokes. The stroke of the signature is not the same thing as the handwritten. Then another thing that it was written under duress, and that he was written that thing under duress means that he was not himself while he was written it. I hope I'm clear, sir. Hello, sir.
I'm with you, sir. I'm with you, sir.
Okay. I said there are two things. The first thing is that when you analyze his signature and the one written by the police, both of them, even though they use the same pen, will not. You can deduce it from from the examination that the person wrote the signature is different from the one who wrote the writings there, the confession. Then another thing is that when you write under duress or under fear, your signatures, your handwriting or signature differs, like when you write under normal condition. So you can use that one to prove that the person who wrote that wrote it under duress or under the fear of, if you don't write this thing, I'm going to do this thing to you. Any other question? I think that one is okay. Do you understand me, sir?
Yeah, yes, sir. Yes, sir. I'm okay, sir.
Any other question? Okay. In the absence of none, once again, you are welcome. Please go to check into your email. Check your email. There's a mail from Forensic Investigator Society inviting you to Google Classroom. Please click on it, accept it. When you accept it, it gives you access to the Google Classroom. Inside the Google Classroom, the handout will be sent to that place. If you have any question, maybe for that question later, send to that place. When I give answer to the question, all of us can see it together. You can see it. Or if there's anyone that has any question that is different from the topic that you are treating, just send the question to that place. Then from that platform also, you are going to have your assignment, because after every class, there's going to be an assignment that you have to submit before the next day. Before the next week.